The highest court in the land is now looking into overturning Hawaii's strict gun laws.
As the nation deals with a recent wave of mass shootings, the Supreme Court expanded gun rights.
State can't make everywhere a sensitive place. You can't go hiking in some places and not be able to defend yourself against somebody that you run into.
Businesses are welcome to put up signs that say this is a gun-free zone, but if you don't, then it's expected that you are able to carry on that property.
The law the Supreme Court justices have their eye on is one that prevents people from carrying guns in certain public places.
The Supreme Court just dropped an emergency ruling that's sending shockwaves through every state capital in America. 26 states have already picked their side. The Department of Justice made a move nobody saw coming, and what happens next will fundamentally change how 330 million Americans exercise their constitutional rights. This isn't another routine gun case. This is the biggest Second Amendment showdown since the landmark Bruen decision, and the fallout has already begun. State governments are scrambling, law enforcement is in chaos, and a multi-million-dollar industry built on permits is watching its foundation crumble in real time. Here's what triggered this constitutional earthquake. After the Supreme Court's Bruen ruling in 2022 made it clear that states couldn't hide behind restrictive may-issue permit systems anymore, most states adjusted their laws accordingly. But Hawaii had other plans. They looked at that Supreme Court decision and engineered something even more restrictive than what Bruen had just struck down. Hawaii created a system that flipped the entire concept of public carry on its head. Under their new law, you could only carry a firearm on private property if the owner gave you explicit written permission beforehand. No posted signs saying firearms were welcome. You're automatically breaking the law just by walking through the door. This wasn't regulation anymore. This was elimination by bureaucracy. The numbers tell the real story. Hawaii's law made 99.8% of private property off limits by default. Gas stations, shopping malls, parking lots, grocery stores, all banned unless you could produce written permission. The state's own attorney general admitted fewer than 0.4% of businesses would ever post firearms welcome signs. They knew exactly what they were creating, a permission trap designed to make legal carry virtually impossible. But Hawaii wasn't operating alone. California, New York, New Jersey, Maryland, and Massachusetts all watched the Bruen decision land and immediately started drafting similar workarounds. Between 2022 and 2024, these 5 states passed 47 new firearm restrictions, with Hawaii leading the charge at 14 separate laws. They weren't trying to comply with Bruen, they were trying to defeat it. When lower courts somehow upheld Hawaii's law, the Supreme Court found themselves staring at legislation that openly challenged their authority. The circuit split that emerged couldn't be ignored. Hawaii had built their entire defense around a single historical example from the 1800s that had nothing to do with modern permit systems. 3 other federal circuits had already rejected similar arguments. The stage was set for a constitutional showdown. Then something extraordinary happened that changed everything. The Department of Justice, which typically defends state gun regulations, filed a brief that essentially admitted Hawaii's system was indefensible under Bruen. They didn't mince words. The DOJ stated outright that Hawaii's law wasn't about protecting property rights. It was engineered to suffocate carry rights through a permission structure with zero historical foundation. The federal government's top lawyers used the word pretextual 4 times in their brief. That's legal speak for calling someone a liar. They pointed out that existing trespass laws already give property owners all the tools they need to exclude armed visitors. So why create this elaborate default ban system? Because the goal was restriction, not protection. But the DOJ didn't stop at filing a brief. They formally requested to participate in oral arguments on the side of the challengers. In the last 40 years, the federal government has switched sides in a Second Amendment case at the Supreme Court exactly 3 times. This makes number 3. When the country's top legal office actively helps dismantle a state's permit structure, every courthouse in America takes notice. State attorneys general started emergency conference calls. Legal defense funds reallocated millions in resources overnight. Everyone realized the battlefield had fundamentally shifted. And just when permit-heavy states thought they'd seen the worst, 26 states filed briefs joining the challenge against Hawaii. Not 2 states, not 5, 26. That's more than half the country arguing that Hawaii's model represents an unconstitutional threat to national consistency. To understand why this matters so deeply, you need to see exactly how Hawaii's permission trap worked on the ground. The system was deceptively simple but devastatingly effective. Instead of, you can carry unless a property owner says otherwise, Hawaii declared, you can't carry unless someone grants explicit written approval. They transformed the Second Amendment into a permission slip that most property owners would never know they were supposed to issue. Consider what this meant for a law-abiding gun owner who jumped through every hoop. You completed Hawaii's permit process, paid all the fees, passed background checks, finished mandatory training, and received your state-issued permit. You walk into a grocery store to buy milk. Is there a sign saying firearms are welcome? Of course not. Under Hawaii's system, that absence of a sign meant you just committed a crime. The store owner didn't have to post "no guns allowed." They didn't have to say anything at all. Their silence became a legal trap, and Hawaii knew it. Internal legislative emails revealed lawmakers specifically discussed how most businesses wouldn't bother posting permission signs and how that would create a de facto carry ban. They said the quiet part out loud in their own communications. This represented a complete inversion of Bruen. The Supreme Court had made clear that the right to carry is the default position, and any restrictions need strong historical justification. Hawaii flipped that entirely. The ban became the default, and permission became the exception. Even the notoriously liberal Ninth Circuit struggled to find historical support, citing exactly two examples from the 1860s that other circuits had already rejected. The implications reach far beyond gun rights. If Hawaii can redefine the starting point of the Second Amendment, what stops states from doing the same to the First Amendment or Fourth Amendment? The Supreme Court is about to answer that question, and their decision will echo through every area of constitutional law. But this stopped being just about Hawaii the moment the Supreme Court agreed to hear the case. If they strike down Hawaii's model, the impact cascades across the country like dominoes. California, New York, New Jersey, Maryland, Illinois, and Massachusetts all built nearly identical structures, hoping courts wouldn't swat them down individually. If Hawaii loses, that protective shield disappears overnight. The timing couldn't be more explosive. Right now, 127 separate lawsuits challenging state carry restrictions sit paused in federal courts waiting for this signal. Lawyers have delayed filings. Judges postponed hearings. States have been desperately buying time, praying the Supreme Court wouldn't intervene. That gamble is about to fail spectacularly. The moment this ruling lands, every one of those cases springs back to life simultaneously. Plaintiffs will file for immediate injunctions within hours. States will scramble to rewrite statutes overnight. Federal courts will have to rule based on brand new precedent that just demolished their previous framework. We're talking weeks of chaos, not months. Look at what's already happening before the ruling even drops. New York quietly stopped enforcing 3 post-Bruen restrictions in January after internal memos warned that defending them was legally untenable. California delayed 2 planned permit requirements indefinitely. New Jersey's Attorney General told prosecutors to exercise discretion on permit violations, code for "don't enforce this because we'll lose in court." These aren't minor adjustments. These are state governments backing down because they see the constitutional freight train coming. The ruling will create a national standard that every state must follow, whether they like it or not. What nobody's discussing publicly yet is the secondary shockwave about to hit. Once permit requirements fall, what happens to the massive financial ecosystem built around them? This isn't hypothetical. It's a fiscal earthquake about to devastate state budgets and private contractors who've grown fat on mandatory training fees. The numbers are staggering. California collected $47 million in permit fees last fiscal year. New York brought in $38 million. Illinois collected $29 million. Across all permit-heavy states, that's over $200 million annually from application fees, renewals, training requirements, and administrative charges. And that's just government revenue. The private sector built around mandatory training dwarfs those numbers. Industry estimates put required carry training courses at $680 million annually nationwide. This created an entire ecosystem. Companies printing certificates, shooting ranges built specifically for state-mandated courses, software firms selling applicant tracking systems. When permits become optional, that revenue stream evaporates overnight. States are already feeling the pain. Hawaii's permit division employed 47 staff members in 2023. By February, that dropped to 19 because applications plummeted 78%. New York has refunded nearly $7 million to 14,000 applicants for training courses that courts blocked. California stopped collecting their $100 issuance fee in December, losing over $1 million monthly. The fiscal impact reports paint a brutal picture. New Jersey's Treasury estimated that eliminating permits creates a $41 million budget hole with no plan to fill it. Illinois projected $33 million in losses. These aren't abstract numbers on a spreadsheet. These represent staff salaries, office leases, and IT systems that suddenly have no funding source. The private training industry faces complete collapse. 3 of the largest carry training companies filed bankruptcy between November and February, all citing anticipated regulatory changes that would eliminate mandatory training requirements. Thousands of instructors who built careers on state-mandated courses are watching their livelihoods disappear. But the financial chaos pales compared to what's happening to law enforcement caught in an impossible position. Police chiefs and sheriffs find themselves enforcing laws that might be unconstitutional within weeks. In January, 19 California sheriffs issued a joint statement declaring they'd no longer check carry permits during stops unless the person was committing another crime. Their reasoning was blunt. We cannot, in good conscience, enforce a requirement the highest court may strike down within weeks. That's 19 elected officials publicly refusing to enforce state law. Not because they're anti-government rebels, but because they're protecting themselves and their departments from civil liability. A December survey of 340 police chiefs across 8 states found 62% had issued internal directives telling officers to use discretion on permit violations. Translation: look the other way unless there's a compelling public safety reason. They're choosing to protect their officers from potential lawsuits rather than enforce laws hanging by a constitutional thread. Prosecutors made similar calculations. Between June and January, district attorneys in 14 counties dismissed over 1,800 pending charges related solely to permit violations. Not charges involving prohibited persons or tied to other crimes, just permit paperwork violations for otherwise law-abiding citizens. They know that if the Supreme Court rules against Hawaii, every conviction becomes a potential civil rights lawsuit with massive damages. Gun control organizations went into full crisis mode. Every town held 3 emergency strategy sessions in January alone. Leaked communications show them discussing alternative regulatory frameworks and post-permit strategies, not exactly the language of confidence. Giffords Law Center redirected millions from state lobbying to federal litigation support. They're not fighting to win anymore. They're fighting to limit how badly they lose. This battle transcends typical gun politics. The Supreme Court is weighing whether constitutional rights begin with the citizen or with government permission. If the answer is the citizen, then every state that built policies around permission first, rights second, loses its entire foundation. For decades, states argued that gun rights were somehow different, that requiring government permission was reasonable in ways it wouldn't be for speech or religion. The Supreme Court rejected that notion in Bruen, declaring that the Second Amendment deserves the same protection as the First or Fourth. But permit states didn't listen. They kept treating gun ownership as a privilege subject to bureaucratic approval. Hawaii took this philosophy to its logical extreme. They built a system where you have no right to carry anywhere unless random property owners grant written permission. The historical test Bruen established makes this approach legally radioactive. Legal historians found 0 examples of blanket permission requirements for carrying arms in early America. So what does America look like if permits disappear? We already have the answer. 29 states currently allow permitless carry. Between 2010 and 2024, 21 states made the transition. Crime didn't explode. FBI data shows violent crime in constitutional carry states decreased more than in permit-required states during the same period. Vermont never required a permit, not in 2024, not in 1924, not ever. They consistently rank among America's safest states with one of the lowest gun homicide rates. Maine adopted constitutional carry in 2015. 10 years later, their gun homicide rate sits lower than before the law changed. New Hampshire went permitless in 2017, South Dakota in 2019. Neither experienced increases in gun violence. What permitless carry actually does is eliminate bureaucratic obstacles for law-abiding people while doing nothing to help criminals who weren't getting permits anyway. Implementation varies by state. Some went fully permitless, others kept permits as optional for reciprocity with other states. Training shifts from mandatory government requirements to voluntary private education. The Supreme Court ruling won't create one uniform system overnight. It'll establish a baseline that states must meet while leaving room for variation. The practical rollout will unfold over 18 to 36 months as states update statutes, courts resolve pending cases, and law enforcement adapts to new realities. Some jurisdictions will move quickly because they can read the constitutional writing on the wall. Others will drag their feet until lawsuits force compliance. But the direction is crystal clear. America is moving toward a system where the right to carry doesn't begin at a permit office, doesn't depend on bureaucratic approval, and doesn't require paying fees to exercise constitutional rights. It begins with the citizen, as the founders intended. The Supreme Court is about to make that principle the law of the land. A multi-billion-dollar permit industry will collapse. States will scramble to fill budget holes. Law enforcement will adapt to new enforcement priorities. And millions of Americans will discover their constitutional rights don't require government permission slips. That's it for today, folks. See you in the next video.